This hearing will come to order. I want to thank you all for joining us for this hearing of the Senate Judiciary Committee. Name is Senator Alex Padilla, been asked by Senator Durbin to chair today's hearing, and I thank him for this opportunity as we will be hearing from 6 outstanding judicial nominees. Judge Holly Thomas for the Ninth Circuit, Judges Mamey Frimpong and Hernan Vera for the Central District of California, Judge Jennifer Thurston for the Eastern District of California, Judge Mary Catherine Dimke for the Eastern District of Washington, and Charlotte Sweeney, who is joining us remotely for the District of Colorado. Welcome to each of you and to your loved ones, and thank you all again for joining us. Before we introduce these outstanding nominees, I'd like to say a few words of thanks to my colleagues on this committee. Over the past 9 months, we've made incredible progress helping the president reshape the federal judiciary to better reflect the people and the needs of our nation. For too long, corporate lawyers and former prosecutors have been overrepresented on the federal bench. Let me be clear, their expertise is valuable and important, and I've been proud to support the nomination of some of these nominees this year. But we also need the knowledge of legal professionals who have taken other paths, public defenders who uphold the constitutional commitment that every person deserves fair representation, public interest lawyers who defend fundamental rights and the rule of law, consumer and voting rights attorneys, labor and local government lawyers, and so many others who serve diverse clients, advocate for different interests, and bring critical insights on how everyday Americans interact with the law. We need all these perspectives to rebalance our federal courts and hopefully strengthen public confidence in the fairness of their rulings. A federal bench that includes more diverse voices provides better justice for all. And this committee has answered that call, working alongside the president to quickly process nominations of a new generation of professionally diverse, outstanding legal thinkers. We're also building a federal bench with a greater diversity of lived experiences. We've heard from and advanced nominees who are immigrants and children of immigrants, nominees who identify as LGBTQ, religious minorities, diverse in race, ethnicity, and gender. Of course, we still have a long way to go and much more work to do. 230 judges were appointed to the federal courts during the previous administration. More than 80% of them were white, and nearly 80% of them were men. So we must continue working together to confirm a federal judiciary that better reflects the nation it serves. And as the first Latino to represent the state of California in the United States Senate, I have a particular appreciation for the importance of diversity in all areas of government. Our country is stronger and fairer when our government reflects the voices and the experiences of all our people. I'm proud of the work we've done so far to advance that goal on the federal bench, and I'm committed to keeping up our critical work. Now, before I have the pleasure of introducing several of our nominees, I'd like to invite Ranking Member Grassley to offer his opening statement.
Thank you, Senator Padilla. Of these 6 nominees, 1 is from the Ninth Circuit, 5 for district courts, California, Colorado, and Washington. Several of the nominees have long histories of working in civil rights issues, but also working as progressive activists. Of course, civil rights lawyers can make very great judges. After all, 30 years ago, the Senate confirmed a civil rights lawyer to the Supreme Court. That's Justice Clarence Thomas. He spent nearly a decade leading the Equal Employment Opportunity Commission and Assistant Secretary of Education in the Office of Civil Rights. Now, the dark money groups pushing this administration's nominees aren't big fans of Justice Thomas. I like to think it's because they oppose his judicial philosophy. He's demonstrated a commitment to originalism and textualism. He's consistently, even-handedly upheld the rule of law. Liberal activist groups like Demand Justice seem to have adopted the opposite philosophy. They start with the answer they want and work backwards to what the legal rule should be, regardless of what Congress wrote in the statutes to say. I hope to hear from the nominees today about the approach that they would bring to the bench. It would be a nice surprise to find that this administration nominees were committed to the rule of law and civil rights as Justice Thomas was. Today's nominees, thank you very much for being here, for testifying, and we compliment you on your nomination and welcome your families as well. For the benefit of the leadership of this committee, as well as my Republican colleagues, I'm going to be here through the Ninth Circuit nominee to ask questions. Then I go to the Judiciary Committee. We have a vote. I hope I get back in time to ask questions of the district court nominees, but for my Republican colleagues, if I'm not here, I hope some Republican will take leadership of the Republicans. Thank you.
Thank you, Ranking Member Grassley. We've been joined by Chair of the committee, Senator Durbin. Senator Durbin, any opening remarks?
Thank you, Mr. Chairman and Senator Grassley. I want to begin by thanking both of you for chairing today's hearing. 4 of the 6 nominees are for California seats, and I want to thank Senators Padilla and Feinstein, as well as their staff effort to fill these vacancies. I'm pleased to welcome our 6 nominees and their families. I could go through the list, but I know that we have colleagues waiting. I do want to highlight one in particular, Charlotte Sweeney, who's joining us remotely. Ms. Sweeney unfortunately tested positive for COVID-19 a few days ago and has decided to testify by video for obvious reasons. It's a testament to Ms. Sweeney and her perseverance that she wished to remain on today's agenda. I wish her a speedy recovery, and no doubt the people of Colorado would be well served by her, and I'm sure Senator Bennett's going to back that statement up. All 6 of the nominees on today's slate will be ready on day 1 to be effective, impartial, and even-handed. They represent an important cross-section of professional experience. Though 5 of the 6 are currently state court or federal magistrates, collectively, the 6 nominees have worked on civil rights, public interest, and labor law as attorneys for state, county, and federal agencies, including the Department of Justice, and serving as federal prosecutors. Their qualifications are impressive. They understand the difference between being an advocate and being a judge and the limited role they assume in the judiciary. And above all, they know their allegiance to the Constitution and the rule of law. I welcome all of them and congratulate them on their nominations. Thank you, Mr. Chairman.
Thank you, Chairman Durbin. It is now my honor to introduce the 4 nominees from the great state of California. All highly qualified nominees, outstanding legal thinkers, and dedicated public servants. Judge Holly Thomas is a proud San Diego native, and she's joined today by her husband, Dagan, her son, Torrin, her sister, Megan, and other close friends. Judge Thomas is a dedicated advocate for equality under law and has made a career fighting to ensure the civil rights of all Americans. A graduate of Yale Law School and a former Ninth Circuit clerk, Judge Thomas spent over 10 years working on civil rights litigation and appeals at the NAACP Legal Defense Fund, in the appellate section of the Department of Justice's Civil Rights Division, and in the New York Solicitor General's office. In each of these roles, she was a tireless advocate for equal justice, a skilled appellate lawyer, an insightful thinker, and a valued colleague. In 2016, Judge Thomas returned to California to serve as the chief liaison between the largest civil rights regulatory body in the state, the Department of Fair Housing and Employment, and the governor's office. She dedicated herself to protecting workers and families from unlawful discrimination. Recognizing Judge Thomas's outstanding work, in 2018, then Governor Brown appointed her to the Los Angeles County Superior Court. There, Judge Thomas requested to serve in a family law division because of her great empathy for families, engaging in difficult court processes. As the first person in her family to go straight to college after high school, Judge Thomas knows what it's like to navigate unfamiliar institutions. As the granddaughter of sharecroppers, she is a passionate fighter for equal justice. And Judge Thomas's compassion is matched by her legal acumen. I know she'll serve with distinction as a judge on the Ninth Circuit. Next, I want to introduce Mame Frimpong, Judge Mame Frimpong, who is joined today by her husband, Yao, her parents, Theodora and Kweku, her in-laws, and other loved ones. Judge Frimpong, a Los Angeles native, is the proud daughter and wife of immigrants from Ghana and a dedicated advocate for equal justice. A graduate of Harvard College and Yale Law School, Judge Frimpong learned the value of education from her grandparents, none of whom had a high school diploma, and understood at an early age the power and responsibility of public service. As a young attorney at the Department of Justice, her work focused on protecting consumers and holding accountable those who had done them harm. In 2010, she earned the highest award presented by the Attorney General for her outstanding litigation work. After leaving the Justice Department, Judge Frimpong became Vice President and General Counsel for the Millennium Challenge Corporation, where she worked to fight poverty and strengthen democracy around the world. And in 2016, Judge Frimpong joined the California Superior Court for Los Angeles County as an appointee of Governor Brown. She's known for the empathy and respect that she displays towards every lawyer and defendant who enters her courtroom, and she's regarded as a superstar by her colleagues, many who have submitted letters to this committee in support of her nomination. In addition to her skill and fairness as a jurist, Judge Frimpong is a dedicated educator, helping students to better understand the legal system and see the limitless possibilities of their own careers. Californians of the Central District will be lucky to benefit from her wisdom and her legal skill. Next, Judge Jennifer Thurston is here along with her husband Mark and daughter Paige. Judge Thurston earned her law degree as a night student at California Pacific Law School, balancing the demands of a full course load with an even greater demand of working and raising her children. After graduating, Judge Thurston spent a decade serving as county counsel for Kern County. Her reputation for diligence and outstanding litigation skill earned her an appointment to serve as a federal magistrate judge in Bakersfield, California. Today, she serves as the chief magistrate judge for the Eastern District of California, one of the most impacted dockets in the country, and she's known for her leadership, her fairness, and her work ethic. She's deeply rooted in the Eastern District's legal community, where she has served admirably as a judge for over a decade, and she's a constant student of the law, returning to school in 2018 to earn her LLM from Duke. With already high caseloads further worsened by the ongoing pandemic, Judge Thurston's confirmation to the Eastern District Bench cannot come quickly enough. And finally, I'm proud to introduce Judge Hernan Vera, who is here along with his wife Barbara, his mother Elvira, and his brother Leandro. Judge Vera is a thoughtful jurist who has long demonstrated his commitment to the rule of law. The son of Argentine immigrants, Judge Vera earned his undergraduate degree from Stanford and a JD from UCLA's School of Law. He has since had a diverse legal career, split between time in corporate law, over a decade in pro bono legal services, and now as a judge. In every respect, Judge Vera is known as a star of California's legal community. His 12 years of service at Public Counsel, the nation's largest pro bono law firm, is particularly notable. First, as director of the Consumer Law Project, and then as the organization's CEO, Judge Vera worked tirelessly to expand access to justice for consumers, veterans, the elderly, and the working poor. In 2020, Judge Vera was appointed to the California Superior Court for Los Angeles County by Governor Newsom, where he adjudicates child dependency cases. Overseeing a high volume of complex and sensitive cases, Judge Vera dedicates himself to finding just outcomes in what are often the most difficult of circumstances. His diverse legal and professional experiences and lessons learned from judicial service will make him a welcome addition to the Central District's bench. I urge my colleagues to confirm each of these highly qualified nominees who have so graciously raised their hands to serve California and our nation. And I thank them for their continued service. And this time, I'd like to recognize Senator Murray for introduction of nominees from her state.
Thank you very much, Chairman Padilla, Ranking Member Grassley. It is my honor today to introduce Judge Kit Dimke for a district court vacancy in the Eastern District of Washington. To begin, I do want to thank President Biden for nominating Judge Dimke for this position at my strong recommendation. I also want to recognize my nonpartisan Judicial Merit Selection Committee, chaired by Andy Miller and comprised of top Washington state lawyers who practice in Eastern Washington, who so ably guided us in selecting Judge Dimke for this position. Let me share a little bit with you about Judge Kit Dimke. She is currently a federal magistrate judge for the Eastern District of Washington. She knows the current judges and all court components well, having served in that role since 2016, and is a highly respected judicial colleague. Given this current role, she has substantial experience in both criminal and civil federal litigation. She's active in court governance and local public outreach and would continue this type of leadership if confirmed. She serves as the vice chair of the Ninth Circuit Magistrate Judge Executive Board and participates in the court's Judicial Institute, volunteering to judge the court's civics competition for students. She's actively engaged in the court's external outreach involving the issue of missing and murdered Native American and Indigenous women, a significant and serious problem facing tribal communities in Washington state. Her entire career has been in public service, and she previously worked as an assistant U.S. attorney in both the Eastern and Western districts of Washington. A native of Washington state, she grew up in rural Asotin County as the child of a cattle ranger and a lumber mill owner. She knows Eastern Washington. Judge Dimke attended the Running Start program at Walla Walla Community College in high school and went on to obtain her undergraduate degree from Pepperdine University and law degree from Vanderbilt. Judge Dimke is someone who has a proven track record, who's committed to improving access to the court, and will identify ways for the court to work equitably for all participants and for each voice to be heard. She has already demonstrated herself in this way, having, as a magistrate, worked to expand the court's mediation services, improved and diversified the court's indigent defense services, and more quickly resolved one of the top areas of litigation the Eastern District sees, Social Security disability appeals. Judge Dimke is eminently qualified to become a federal district court judge and will make an excellent addition to the federal bench from the Spokane Courthouse. I urge my colleagues to support her nomination. Thank you very much, Chairman Padilla and Ranking Member Grassley.
Thank you, Senator Murray. Next up is Senator Bennett, here to introduce Ms. Sweeney.
Thank you, and congratulations, Mr. Chairman, on your ascension to this role. I also want to thank Chairman Durbin for allowing me to be here, and Ranking Member Grassley as well. This is a great moment for Colorado, and I'm grateful to have the chance to join you this morning to introduce Charlotte Sweeney, President Biden's nominee for the U.S. District Court for the District of Colorado. For Charlotte, equality under the law is no abstraction. It is her life's work. A native of Littleton, Colorado, Charlotte grew up hiking and skiing with her family on the Rocky Mountain trails within an hour of their home. Today, she hits the same trails with the two most important people in her life, her teenagers, Jordan and Addison. As much as Charlotte loves our state, she also remembers a time when it wasn't easy for LGBTQ Coloradans like herself to be open about who they were, especially at work. It was a time, instead of leading the nation on equality, Colorado actually passed an amendment that blocked any laws to protect LGBT people from discrimination. When the Colorado Supreme Court declared the amendment unconstitutional, Charlotte saw the power of the law to tip the scales for or against equality, and she decided to spend the rest of her career on the side of equality. After graduating summa cum laude from the University of Denver College of Law, she joined a small firm that focused on representing plaintiffs. She rose to become a partner in just 2 years, and just 2 years after that, she became a named partner of the firm. That would have been enough for most people, but Charlotte kept on going. In 2008, she started her own firm to represent individuals on employment law cases. And over the past 20 years, Charlotte has become one of Colorado's top employment attorneys, representing federal, state, and private sector workers in virtually every area of employment law. In one case, she represented her former law professors at the University of Denver, who'd been paid less than their male colleagues for decades. She obtained $2.6 million in relief for her clients on top of their overdue pay raises. Sadly, that outcome isn't the norm in America, where our justice system too often sides against workers, even when the facts of the case are on their side. That is corrosive to the American people's confidence in the rule of law, and it's why we need more judges with Charlotte's perspective, seeing the legal system through the eyes of workers. Charlotte's obvious credentials, integrity, and much-needed experience more than qualify her for this role, which is why I strongly support her nomination. Mr. Chairman, if confirmed, Charlotte would also become the first openly gay woman to serve as a federal judge west of the Mississippi, a powerful affirmation of America's commitment to opportunity and equality for all. So I want to thank the committee for considering this exceptional nominee, and I urge members of both parties to send her to the floor with a strong bipartisan vote.
Thank you, Senator Bennett. Also joining us to offer some introductory remarks for Ms. Sweeney is your colleague from Colorado, Senator Hickenlooper, who will be joining us virtually. So if we can try to patch him in via WebEx. He'd be here in person, but as is often the case around here, has multiple committees meeting at the same time. So he has a scheduling conflict, but making an effort to join us virtually. Senator Hickenlooper, are you with us? In the meantime, Senator Murray, Senator Bennett, thank you for your introductory remarks. And Judge Thomas, if you can come forward while we give Senator Hickenlooper just a few more seconds. Otherwise, his shot clock will expire and we will move on. Okay, he's signing in right now, we're told. He may be very well tied up in questioning in another committee. So we will move on. If he's able to join us later in today's hearing, we'll certainly make accommodation. So at this point, I want to thank the senators for their introductory remarks. We will now proceed to panel one. Judge Thomas, thank you for being here. Let me ask you to stand and be sworn in. Judge Thomas, do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you. You may be seated. Judge Thomas, you may now proceed with your opening statement.
Thank you. I'd like to begin by thanking Chairman Durbin, Ranking Member Grassley, and members of the committee for considering my nomination today. Thank you as well to Senators Feinstein and Padilla for your support, and Senator Padilla for your kind introduction and for chairing this committee this morning. And of course, I would like to thank President Biden for the honor of this nomination. Sitting here before you today, I feel the presence of so many who, through their love and support, have carried me into this room. My grandmother, Ida, born a sharecropper in North Carolina, who stood proudly beside me at my law school graduation. My father, Keith, the hardest working person I know, a school custodian all my youth, who worked as a chauffeur at night to help put me through Stanford. And my mother, Venus, a retired bookkeeper. Although my mother, like my father, had not gone to college, and although she had no connection to the law, when I told her at the age of 5 that I wanted to be a lawyer, she started taking me to court so that I could begin to learn about the legal system. My reverence for the Constitution, my admiration for the judicial process, and my profound respect for the rule of law, it all started there and beside her. To my parents and my other family members, to my friends and colleagues both here and supporting me at home, thank you. I would especially like to thank my sister Megan, who is here today representing our parents and our family who were not able to travel to Washington, D.C. And to my husband Dagan and our son Torin, who sit here behind me. Words are not adequate to express my love for them. I could not be here without their support. So it is with an immense spirit of gratitude and with a love for this country where the granddaughter of a sharecropper can sit before the Senate to have it consider her nomination that I look forward to your questions for me. Thank you. Thank you, Senators.
Thank you, Judge Thomas. We will now turn to questions from the committee. Each senator will have 5 minutes to question Judge Thomas, and I will begin. Judge Thomas, prior to joining California Superior Court bench, you had an impressive career as an appellate and civil rights litigator, including time at the NAACP Legal Defense and Education Fund, the Department of Justice Civil Rights Division Appellate Section, and the New York Solicitor General's Office. I know you've authored briefs for and advised on countless appellate matters and had a dozen arguments in appellate courts. Since your appointment to the bench, you've served for 6 months as a pro tem judge on the California Court of Appeal, publishing 7 opinions already. Would you mind sharing with the committee how each of these various experiences will contribute and inform your service on the Ninth Circuit and make you ready to serve on day one?
Thank you, Senator Padilla. I was so fortunate before being appointed to the Superior Court to have a really broad background as an appellate advocate for over a decade and 14 years as an attorney. I have briefed nearly 3 dozen appeals before the United States Courts of Appeals or the Supreme Court, and a dozen cases before state courts of appeal. I've argued cases before the United States Courts of Appeals for the 1st, 2nd, 4th, 5th, and 9th circuits, and cases before the New York State Supreme Court Appellate Division. I've handled a broad range of issues, ranging from criminal law and procedure to the employment rights of our returning service members to the Prison Litigation Reform Act. And indeed, earlier this year, I had the opportunity to sit as a pro tem judge on the California Court of Appeal, where I sat on nearly 2 dozen panels and authored 7 unanimous opinions. So I bring all of this to bear. I'll bring all of this to bear if confirmed. I've learned so much from colleagues, so much from my work, and feel ready for the position to which I've been nominated. Thank you very much.
Thank you. And an additional question, having served as both an advocate and as a judge, can you speak to the difference between the 2 roles and how you undertook the transition from an advocacy role to jurist upon being appointed to the bench?
Yes. there's a sharp difference between being an advocate and being a judge. As an advocate, you are zealously advocating for the views of your client, as you're ethically bound to do. Being a judge is a different task, and I know that as I've sat now as a judge for the past 3 years, including on the Court of Appeal. As a judge, you're looking at the law, you're looking at the text, you're looking at precedent, and that is what guides you. So it's a very different task. It's one that I willingly accepted when I was appointed as a judge to the Superior Court.
Thank you. And an additional question. Since your 2018 appointment to the Superior Court, you spent the bulk of your judicial service in the Family Law Division, an assignment which I understand you requested. In that role, you're responsible for managing at times 15 to 20 matters per day, an immense workload for any judge. Considering your breadth of legal experience, you certainly could have served in many of the Los Angeles Superior Court's divisions. Why did you request to go specifically to the Family Law Division?
Thank you for the question, Senator Padilla. So throughout my 14 years and as an appellate advocate, one of the things that I always enjoyed was taking on new and complex issues and challenging myself. And family law offers all of that. We deal with complex issues of property, financial issues, civil law issues. And that's something that I've enjoyed. But beyond that, I saw, Senator Padilla, the importance of joining my colleagues in the work of listening, the work of really hearing the litigants who come before us, making sure that their claims are understood, and that in decision after decision, case after case, I'm offering litigants a clear statement of why the law has commanded me to reach the result that I've reached. Now, it doesn't mean that everybody agrees. It doesn't mean that everybody is happy. But my goal is that everyone walks out of my courtroom feeling respected and feeling that the work of justice has been done.
Thank you. Senator Grassley.
Yeah. Congratulations on your nomination. And as we usually do, you made some statements in the past that I want to make some questions to you about. Last week, we learned that the Loudoun County School Board in Virginia covered up the fact that a male wearing a skirt had sexually assaulted a 14-year-old girl in the girls' bathroom at the school. The same boy allegedly later assaulted another girl at a different school. In 2016, you argued in multiple briefs that concern about the safety of young girls in school bathrooms were unfounded. In one brief, you argued this, quote, no data or tangible evidence in support of that claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime. In light of the troubling news about Loudoun County, do you still believe that concerns about safety and privacy, especially for young girls in school bathrooms, are valid?
Thank you for the question, Senator Grassley. When I was an advocate and at the New York Solicitor General's office, in that case, I advocated the views of my clients. So we filed a brief taking a certain position. I'm not familiar with the case that you just mentioned, but what I will say is that as a judge, I know that my role is to set aside whatever it is that I did as an advocate and be guided only by the law. And that, I promise you, is what I do now and what I will continue to do if confirmed. I'll be guided by the law, I'll be guided by precedent, I'll be guided by the record before me and nothing else.
Okay. You may give the same answer to my next question, and if you want to not repeat it, you don't have to if it's the same answer. In a brief arguing against the North Carolina school bathroom law, you suggested, quote, privacy curtains and separate, also quoting, changing spaces would be sufficient to protect school-age girls from predatory acts in the bathroom. How would privacy curtains or change of spaces have prevented the sexual assault in Loudoun County, and I guess you said you didn't know much about that. It really hit the news out here, so I'm going to go on to another question. Does federal law require private businesses to provide access to restrooms and locker room facilities that align with an individual's gender identity and gender expression?
Thank you for the question, Senator Grassley. Now, that's an issue that I understand is one being debated, it's one being litigated. And as a sitting judge and as a judicial nominee bound by codes of conduct, I can't comment for you on what I think or how I think the law would resolve those issues. What I can commit to you again is that as a judge now and as a judge on the Court of Appeals, if confirmed, what will guide me is the Supreme Court precedent and the law. I take each case as they come, one by one. I look at the record, I look at the facts, and that's how I make my decision on that and on nothing else. Thank you.
In Simmons versus Galvin, you argued that a law banning felons from voting in election does not violate Section 2 of the Voting Rights Act. Do you still believe that, quote, neutrally designed and enforced, end of quote, voting laws are generally not subject to challenge under Section 2?
Thank you, Senator Grassley. The United States did take that position in Simmons versus Galvin, and I was counsel on that brief. Now, Section 2, as you're aware, requires totality of the circumstances analysis. It's very case specific. The Supreme Court has made that clear. And so any issue regarding Section 2 that came before me, I would handle in that way by taking a really case specific look at the totality of the circumstances, guided by Brnovich, which the court has set forth 5 factors for courts to consider, and that's how I would be led. So I'd be looking at those factors.
Okay. This will have to be my last question. In 2019, you reversed the juvenile court's order requiring substance abuse awareness and treatment as a condition for a drug dealer to have custody of his children. The man was found with large quantities of fentanyl and methamphetamine. He was also found with medicine to treat accidental overdose. But despite this, you found that the juvenile court had abused its discretion by requiring the awareness and treatment programs. Can you explain why it is an abuse of discretion to require drug dealers caught with large quantities of fentanyl and other deadly drugs to undergo awareness and treatment before being allowed to have custody of children?
Thank you for the question. So as I wrote in that opinion, and it was a unanimous opinion of our panel, what the matter turned on was that there has to be, under California law, a connection between the disposition and between the actions that led to the dependency of the children. Now, in that case, I wrote that the father's actions could be the basis for a great many orders by the juvenile court, but that as substance abuse by the father was not a condition that led to the dependency. Under controlling California law, substance abuse treatment for the father was not appropriate, but the decision left open to the juvenile court further actions to address the issues that you mentioned. Thank you.
Thank you, Senator Grassley. Senator Durbin.
Thank you, Mr. Chairman. Judge Thomas, thank you for being with us today. I understand that you don't want to give us any comments on pending litigation or potentially pending litigation, so my questions may be of more philosophical bent to address issues before us. Throughout our history in this country, we have struggled with the issue of race. The Constitution, for all its wisdom, was deficient, in my view, in that it perpetuated slavery in the United States and recognized it, at least indirectly. We're still struggling with that issue today, and we hear that debate in the Judiciary Committee regularly in many different guises. You have been involved in the administration of justice and law enforcement and law throughout your career, in legal services, judicial service, and the like. Tell me, if you will, whether you think we're making progress in this area and what we need to do to make sure that every American, regardless of their race, feels that they're going to be treated fairly under our system.
Thank you for that question, Senator Durbin. So I think it's so important that our society is discussing these issues. I think it's so important that policymakers discuss these issues. As a judge, what I really feel duty-bound to focus on are the litigants who come before me, and ensuring that in every case that I hear every day, that the people who come into my courtroom understand that it's the law that drives the outcome of their cases, not personal viewpoints, not anything else, but the law, and that I give them a clear explanation so that they have confidence, whether they're happy or not, whether they agree or not, that the process of justice has been done in their case. I feel it's important to listen to the litigants, to truly hear the litigants, to listen with an open mind to their arguments, and to ensure that I am carrying out my duties to make the process of justice actually fair, but also feel fair to the litigants who come before me.
I thank you for that, and I just want to add, because it happens with great frequency on both sides of the table here in the Judiciary Committee, that those who come aspiring to judicial office are often reminded of their work as attorneys before, as advocates before, representing clients. And sometimes those of us who've been in private practice understand you may not agree personally with your client, but you're duty-bound professionally to do your best to represent them, short of misrepresentations of fact. And I recognize your earlier answers about specific cases you've been involved in brings that again before this committee. I thank you for being here today. Thank you, Mr. Chairman.
Thank you, Senator Durbin. Senator Kennedy.
Thank you, Mr. Chairman. Judge, congratulations. I'm not going to ask you to comment on any Supreme Court precedent or how you're going to rule on cases. I just want to try to, as Senator Durbin suggested, get to know you a little bit. You serve right now on the Los Angeles County Superior Court. Is that right?
Yes, it is. Thank you.
Is the Los Angeles County Superior Court, in your opinion, systemically racist?
Thank you for that question, Senator Kennedy. So I think that questions regarding racism, regarding systemic racism, again, are very important ones for policymakers to be focused on. I'm focused on my day-to-day work as a judge on the cases that come before me, and I think that I best serve my duty as a judge by keeping that rigorous focus.
I'm sorry to interrupt you, but we have so little time, and I've got several questions. Do you consider the court to be systemically racist? Do you sit on it right now or not?
Again, Senator Kennedy, I feel that I best serve my duty as a judge by focusing on the individual cases that come before me, individual questions.
But the court is an institution. I think it's a pretty straightforward question. Is it systemically racist or not, the Los Angeles County Superior Court?
I understand your question, but I think that those kinds of questions are best left to policymakers, and that as a judge, that what I need to do is to focus on my cases.
You don't want to answer it. I get it. Explain the Erie Doctrine to me. You're going to see that a lot on the Ninth Circuit.
Thank you for the question, Senator Kennedy. Now, in my 14 years as an attorney, as appellate advocate, having handled many different cases, I never had a case regarding the Eerie Doctrine. I'm sure I learned about it in law school. Yeah. I don't recall it sitting here before you now, but I'm certain that I'd be able to to look it up and find the answer for you and come up
Are
to
you
speed.
familiar with Erie v. Tompkins?
I am familiar with the existence of the decision. I'm sure that I read it in law school. I haven't read it recently.
Okay. All right. Name a public policy that you think is a good idea but is unconstitutional.
Thank you for the question. Given that I am a sitting judge and a judicial nominee bound by codes of conduct, I don't think it would be appropriate for me to comment on policies that I believe are constitutional or unconstitutional.
No, I'm not asking you to do that. I'm saying, tell me a policy that you like that has already been declared by the courts that's unconstitutional.
Thank you, Senator Kennedy. So I, as a judge now, and again, if confirmed, am bound to follow Supreme Court precedent. I'm bound to follow Ninth Circuit.
I know
precedent.
that, and I'm running out of time. And if you don't want to answer, I get it. I've got other questions.
Well, it's not, I'm sorry.
Can you name me a public policy? I'm not debating the legality of it. I'll stipulate that it's unconstitutional, or that you think is a good public policy regardless.
Well, thank you. But in my view, I am not served, and my oath is not served by me commenting about my personal views, because my personal views don't drive what I do as a judge, which is to follow the law in every case without reservation, whether I think something is a good
Okay,
or
I'm
bad
running out of
policy.
time, Judge. I still don't understand any of your answers. Let me try one more. Here's a hot topic. Tell me the legal basis for a universal injunction.
Thank you. So injunctions are governed by Federal Rule of Civil Procedure 65. The court has said that injunctions are an extraordinary remedy, and I understand that they are. So the legal basis for a universal injunction or a nationwide injunction is whether it is necessary to give the plaintiffs complete relief, but without imposing an undue burden on
Is that case law or constitutional law?
That's case law.
And what's the cases? What are the cases?
I can't cite for you the specific case, but I've reviewed cases about universal injunctions and understand again that that's an extraordinary remedy, very fact-bound determination about whether those should be issued.
Okay, thank you.
Thank you.
Chairman.
Thank you, Senator Kennedy. Before recognizing Senator Blumenthal, let me just observe there's no additional Republican senators in the committee room at this time. After Senator Blumenthal, if one does arrive, obviously a Republican senator would be next to ask questions. But if not, we will wait briefly before moving on to the second panel. So if the staff would please keep us advised, that'd be helpful and appreciated. Senator Blumenthal.
Thanks, Mr. Chairman. Thank you for your service, Judge Thomas, and thank you for being here today. Congratulations to you and your family. I think we left open the question of what the Erie Doctrine is, and you and I, as graduates of the Yale Law School, probably took the same procedure course, maybe not taught by the same professor. The Erie Doctrine actually is the principle from Eerie v. Tompkins that federal courts apply federal rules of civil procedure, but state substantive law, including state common law. And just for the record, I had to look it up too. So congratulations to Senator Kennedy for educating us all. I'd like to know from you what impact your going to court as a child had on your perspective about your own career choices and whether you'd recommend it for other parents to do, given its impact on you.
Thank you for that question. The opportunity to go and sit in courtrooms beside my mom, it changed my life. I wouldn't be sitting here today without having had those experiences. You get to see firsthand that promise that's written on the front of the Supreme Court, equal justice under law. You see judges doing the hard work day after day of listening to people with heavy case volumes, but of making sure they understand people's claims and making sure that the folks who come into the courtroom understand what the law commands the judge to do. I just think that it is, for young children, as it was for me, a beautiful representation of what our democracy is about. And I absolutely recommend it.
Let me ask you also about your advocacy as an appellate lawyer, for example, for the NAACP Legal Defense Fund. We tend to emphasize here how important it is to put aside your personal beliefs and your past as an advocate, but I think also we should encourage people to be advocates, particularly for public interest groups, regardless of the public interest cause. Could you talk a little bit about how that experience shaped your views of the law, knowing that you're going to put aside your personal views as a member of the Ninth Circuit Court of Appeals?
Thank you, Senator Blumenthal. The most important lessons that I derived from my career was how much the people who come to court just want a chance to be heard. Folks don't know what to expect oftentimes when they walk into a courtroom, whether that be at trial or into a court of appeal. I think people walk in with fear, with a lot of trepidation, and I think people just want an opportunity to really have the judge hear their story. But I'll also say this, that for me, one of the richest aspects of both my personal life and my professional life has been the diversity of the professional backgrounds of the colleagues with whom I work. So, I work now with public defenders, with folks who were prosecutors, people who spent their careers in law firms, people who worked in nonprofits, and each of us bring a professional perspective that it makes the discussion so rich in the court. And I think it's so important to have that. It's been important to me personally.
Thank you very much. Thank you, Mr. Chairman. Thank you for your service, and congratulations on your nomination.
Thank you, Senator Blumenthal. Next for questions is Senator Hawley. He's returned, and if no other additional senators join us, it'll be Senator Blackburn after him.
Thank you very much, Mr. Chairman. Judge, congratulations on your nomination. Thanks for being here. I want to come back to an issue that Senator Grassley raised, and I just want to be sure I understand your position. I'm thinking about these briefs that you signed in two different cases, one in North Carolina, one in Texas. Let me ask you about the North Carolina case first. You argued there that Title VII prohibits disadvantaging someone because of gender nonconformity, regardless of the birth-assigned gender or current gender identity. The brief also suggested that privacy and safety concerns underlying North Carolina's proposed bathroom separation of boys and girls are unfounded, and that the state had not demonstrated any public safety risk. In the Texas litigation, you said there was no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to crime in restrooms. Now, I have to ask you, in light of what we are seeing in Loudoun County, there are reports about this in other places, but it's particularly troubling in light of the recent events in Loudoun County, where a boy in late May was sexually assaulted a 9th grade girl in her school's restroom after he identified as being gender fluid. He was transferred to another school where a second assault occurred just earlier this year. Do you stand by your comments in these briefs that there is no evidence of violence or crime in restrooms by allowing biological males to use biological females' restrooms?
Thank you for the question, Senator Hawley. As I explained to Senator Grassley, in every case that I had as an advocate, it was my duty to represent the views of my clients. And that's what I did in those briefs, which were filed when I worked for the New York State Solicitor General's office. Now, I was not familiar before this morning with the Loudoun County incident, but again, what I would say is this, that I understand well, being a judge now, the difference between being an advocate, advocating for your clients, and being a judge who is duty-bound, who takes an oath, and one that I take very seriously, to apply the law to the facts and the record, and to review each matter individually as it comes before you. And that's what I would do were that issue to come before me, if confirmed.
Yeah, thank you for that. I understand that, and I appreciate your role as an advocate. I'm just curious if you stand by these comments. Do you agree still today that there is no data or evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms? I mean, do you think that that's accurate? You signed those statements. You filed that brief. Do you think that that's right?
Thank you for that question, Senator Hawley. Again, at the time that I filed the briefs, I was representing clients zealously, as I was ethically bound to do. In a new case on new facts, I would have to analyze it based upon what was presented to me, or if sitting on appeal, based on the record.
Well, and I'm asking you to do that now. I mean, I think this is important. You were actually counsel of record in the North Carolina case. You signed the brief in the Texas case. Now, I understand you're representing clients, but of course, I also understand you have a duty not to sign briefs that you think are unethical or that misrepresent facts. So I assume you think that the arguments made in these briefs were correct and accurate. You wouldn't have signed them. Certainly, you wouldn't have been counsel of record. These are quite dramatic claims that you made in both of these cases. And now we have reports in various parts of the country, but Loudoun County most immediately and most publicly, about assault by a biological male of a ninth grade girl, and then a second assault happening. It's exactly what you said in these briefs wouldn't happen. I just wonder, what would you say to the parents of this girl who was assaulted in a restroom at school? She's in ninth grade. I mean, would you maintain to them that their concerns are unfounded, and that they shouldn't be concerned about what happened? I mean, is that the message?
Thank you, Senator Hawley. So, sitting here as a judge, my duty is to review the cases that come before me on the evidence that comes before me. I can't comment on a case that's pending, on a case that might come into my
Well, this
courtroom.
case isn't pending before you.
I can't comment on a case that's pending anywhere per the California Code of Judicial Ethics. So the only thing that I can tell you is, again, that I understand that.
So you know, my time's expired. I don't mean to interrupt you, Judge. I've got to let somebody else ask questions. I just want to be clear. So you stand by these comments. You don't think that you stand by what you filed in these multiple different cases. You don't think you were wrong about that. You haven't changed your view. You wouldn't change anything that you said and that you filed. You put your name to.
So again, I, as an advocate, represented my clients. I didn't represent my personal views about issues in the same way that my personal views don't come into what I do as a judge. And I understand the difference between that advocacy role that I had then and the judicial role that I hold now.
Thank you. Senator Ossoff.
Thank you, Mr. Chairman, and Judge Thomas, congratulations on your nomination. Welcome to your family. I know this is an arduous and intrusive process, and grateful for your willingness to serve. You have extensive appellate litigation experience. Principal clients over the past decade have included the U.S. government, states of New York and California. Can you please characterize for the committee that experience and its relevance to your qualifications for this judgeship?
Thank you, Senator Ossoff. I was so fortunate as an appellate advocate to get to work on a broad range of issues. I worked on criminal law, criminal procedure, on voting rights, on the employment rights of returning military service members, on the Prison Litigation Reform Act, on disability issues, just a really broad swath of appellate litigation issues. I filed briefs, nearly 3 dozen, in the courts of appeal or before the Supreme Court, argued 8 cases in federal courts of appeals, and I bring all of that experience to bear now in my role as a Superior Court judge, and would bring it to bear on the Ninth Circuit if confirmed. I was so fortunate to have the opportunity in case after case to be able to come up to speed on issues, present argument sometimes against advocates who had spent their entire careers in an area of law, and to do so in zealous advocacy for my clients in each case. Thank you.
Thank you, Judge Thomas. And will you commit to the committee that, if confirmed, you will apply and uphold the law, regardless of your personal policy preferences, with impartiality and objectivity to the best of your ability?
Absolutely. It is the oath that I took when I joined the court that I am on now. It's the oath that I uphold every day in my work.
Thank you, Judge Thomas. Could you please share with the committee the lessons that you've learned that you'll apply to a federal judgeship based upon your experience as a judge on the Los Angeles Superior Court? How will you apply that experience to a judgeship on the Ninth Circuit?
Thank you for that question, Senator. Some of the most important aspects of what I do now are just ensuring that every person in every case knows that I have listened to their claims, made an effort to really understand their claims with an open mind, and am rendering a decision that is driven by the law and driven by precedent. And that is true whether I am in my trial courtroom or whether I'm sitting on the Court of Appeal, as I was earlier this year. That is what the public wants. It's what they have a right to have from the court, is a true, fair hearing and a clear statement about why the law commands the outcome that I've reached.
Thank you, Judge Thomas. I want to drill down a little bit on a specific case. When you were at the Department of Justice in 2013, a service member who had deployed to Iraq, when returning to civilian life, learned that his position had been eliminated, his employment here in the United States, and that he'd been effectively demoted at his job due to his deployment. You filed a brief in support of this service member. The service member had sued, alleging violations of the anti-discrimination provisions of the Uniformed Services Employment and Reemployment Rights Act. Can you tell us a little bit more about that case and about your work to protect the rights of service members and others from employment discrimination?
Thank you for the question. It was an honor to be assigned to work on that case, where we argued on behalf of the United States that the Uniformed Services Employment and Reemployment Rights Act applied to a discretionary promotion that the service member in question had missed while he was away on military service. I presented argument before the First Circuit. I presented a brief to the First Circuit, and ultimately that court agreed with the United States and established a precedent that now applies to the rights of service members throughout that circuit. Thank you.
Thank you, Judge Thomas. Thank you for your testimony, and I yield back, Mr. Chairman.
Thank you, Senator Ossoff. Senator Lee has returned. He's next for questions. What a gentleman. Senator Blackburn will
All
be
right,
next with
thank
questions,
you.
followed by Senator Whitehouse, then Senator Lee.
Okay, and I thank Senator Lee for that. We have a Tennessee colleague whose portrait is being unveiled over on the House side, and I need to make some remarks. Judge Thomas, returning to Senator Hawley's question, I think that it should not be lost on you how unsettled that Tennesseans that I represent are by your nomination because of what you have said about the transgender rights and the assault that happened in Loudoun County, but there's also been others, and these are things that have been reported. So people want to know that their children are going to be safe, and they want to make certain that you are not going to be an activist judge. So I want you to talk to me for just a minute about your judicial philosophy and about activism on the bench and how you will set that aside. Just 20 or 30 seconds on that.
Thank you, Senator Blackburn. The oath that you take when you become a judge, the promise that you make to the litigants who come before you is that your personal views have no role in your decisions. I have been a judge.
So you're not going to focus on outcome-based law?
Absolutely not. What drives your decisions is the text and the law and precedent.
Okay. Let me ask you about voting rights, because I had a Tennessean call me early this morning, and they are very upset about what they hear about federalizing of election and doing away with voter ID and stripping states of responsibility, because states do have a constitutional authority, and thereby they also have the responsibility to administer their elections in a way that is going to promote security, is going to promote election integrity. Citizens expect them to do that, and you have taken the position that a state does not have the right to reject an application for voter registration for failure to show proof of U.S. citizenship, to prove who they are. And this Tennessean this morning was talking to me about how they have to prove who they are when they pick up a prescription, when they go to rent a car, when they get on a plane, sometimes even when they're trying to get to the In-N-Out burger to eat inside. They have to prove who they are. So let me ask you this. We feel like it's an essential part of the duty to establishing qualifications of voters, that they be a citizen, that we know who they are. So why shouldn't states be permitted to require proof of U.S. citizenship in order for someone to vote in an election?
Thank you for that question, Senator Blackburn. So in Crawford versus Marion County, the Supreme Court upheld law requiring voter identification. So that would certainly be applicable precedent in any case on that issue that came before me. The court has also held, however, that Section 2 of the Voting Rights Act, and that was what was at issue in the case that you mentioned that I litigated on behalf of the United States, requires a totality of the circumstances analysis. So in Brnovich, the court held that you have to look, among other factors, at the size of disparity, the strength of the state's interest.
So what you're telling me is you do not believe someone has to be a U.S. citizen in order to vote?
Well, thank you for that question, Senator Blackburn. That's not at all what I'm telling you. What I'm telling you is that in a case that comes before me regarding voter ID or any other sort of regulation regarding voting, that I'll apply the Supreme Court's precedents in that area without any hesitation or any reservation whatsoever.
Okay. I've got a couple of other questions pertaining to your work as an advocate and some of the issues that you've taken on voting rights and race-based college admissions. and I'm going to submit those to you for writing, as well as a question that comes from your work as a registered lobbyist. Thank you so much. Thank you, Mr. Chair.
Thank you, Senator Blackburn. Senator Whitehouse.
Thank you very much, Chairman, and thank you so much for being here. Ms. Thomas, could you tell us about the John Marshall Award? It's an award that you received at the Department of Justice during your time in the Civil Rights Division. What is that award, and for what did you receive it?
Thank you very much for that question, Senator Whitehouse. I was very honored to receive from the Department of Justice in 2015 a John Marshall Award, which is for providing legal advice to the Department of Justice. Along with colleagues at the Department of Justice, I provided advice about the application of Title VII to claims of discrimination on the basis of gender identity, gender transition, or transgender status. And so that's what I was awarded for. The Supreme Court, of course, held in Clayton versus Bostock County that Title VII does cover such claims. So I was honored that the department recognized my work on that issue. Thank you.
So a little personal history from me. There were years in my boyhood when I was unusually small compared to my age group, and that created fairly considerable difficulties as a boy. And those years I still remember as being difficult and isolated. And all is well, so there's nothing more to the story than that, except that had I had anxieties and concerns and felt ill at ease about my gender identity, I would expect that that would be a very difficult thing as well. And when we talk about these gender identity issues, we often forget that they arise when people are children and when they're still fighting all the difficulties of being a child and being a teenager, probably even worse. What is your human advice as to the sentiment with which we should engage children who are trying to sort their way through that rather challenging difficulty?
Thank you for the question. So as a parent myself, it's hard to think of what words you'd give to another parent going through challenging times with their child. But what I will say is that as a judge, I think that what our duty is to all litigants, no matter what views they have, what claims they are arguing, is to treat them with respect. And that is what I endeavor to do day after day.
And as a parent and adult, kindness would make a pretty good watchword too, wouldn't it?
I think that it's important, at least in my courtroom, that I be kind to litigants. I'm not, you can't make people happy as a judge. That's not the task. You're not endeavoring that everyone agrees with you. But there's nothing wrong with people coming to court and feeling like they've been respected by the judge who's hearing their case.
And I'll close by observing that even in a libel case, truth is a defense. And my personal feeling is that there's nothing you said about now Justice Kavanaugh that doesn't stand firmly on a pillar of truth. So that's just my opinion, but I want you to know that I have no hesitancy about supporting you based on what you said regarding that sorry episode. I yield back my time. Thank you.
Senator Lee.
Thank you, Mr. Chairman. Thank you, Judge Thomas, for being here. I've agreed with a number of things that you've said, including the fact that you're not there as a judge to make everybody happy. It should be the case that litigants who come before your court should feel that you're going to do your very best to decide the case correctly. Wanted to ask you a few questions. One of them that I don't think anyone's covered yet. You worked for the NAACP, I think, for the Legal Defense and Education Fund for about 5 years, roughly 2005 to 2010. Is that right?
Yes, that's correct.
And I think you were also a registered lobbyist for them at the time.
Yes, I apparently was a registered lobbyist. I didn't recall ever having done any lobbying for them, but I was registered as a lobbyist.
Now, on your, so you did other work for NAACP at the time that wasn't part of your work as a registered lobbyist?
Any work that I did as a registered lobbyist, it had to be an extremely minor portion of my work there because I didn't recall that I had done that.
Okay. Okay. But you did other work that was non-lobbying for the NAACP during that time period?
Yes, I did.
In your Senate Judiciary questionnaire, you said you didn't recall the nature of those activities. Were you referring specifically to the lobbying activities or to your employment as a whole for NAACP?
To the lobbying activities.
Okay. What was the, just briefly, what was the nature of the rest of your work that you did that wasn't lobbying?
Sure. So I came on to the NAACP Legal Defense Fund initially on a fellowship to study the issue of juvenile life without parole sentencing and do policy work around that issue. So I did that for a number of years, and then I also worked on criminal cases and I worked on education matters, both policy and litigation.
Okay. Okay. So your work as a lobbyist would have been incidental to that, and you don't recall any specific lobbying activities?
That's correct.
Right. That makes sense. Just want to make sure I understood that correctly. I want to get back briefly to what Senator Hawley was talking to you about, the brief that you submitted in Texas versus United States. This obviously involves an area that's fraught with a lot of difficulty. Obviously, transgendered people have rights and they need to be protected and certainly need to be able to use a restroom without fear. This can sometimes present difficulties for school districts and people who are trying to make sure that everyone is safe, make sure that no one is likely to abuse a policy for nefarious purposes. One of the things that I found concerning in the brief that you submitted was that you said that, quote, in states where non-discrimination protections are already law, Texas's predicted safety harm has never materialized. It then went on to classify Texas's concerns as, quote, anxiety about possible future bathroom crime as nothing more than unsupported speculation. Now, I totally understand you were writing that on behalf of a client in that case, and that you had an argument to make. But how did you know, or how would anyone know in that circumstance that you knew that no harm could ever materialize? And do you dispute today the fact that harm could materialize by someone manipulating a policy, perhaps crafted with the best of intentions, in order to subject people to harm?
Thank you for that question, Senator Lee. So stepping outside of that case and that context, I don't dispute the proposition that you mentioned. But when you're working on a case, as you know, you're working on that case on behalf of your clients on the facts that you have. And similarly, as a judge, you're ruling on cases one by one as they come before you based upon the facts, based upon the record. That is what I do now and what I would continue to do.
You're aware of the recent incident that's come to light in the Loudoun County School District?
Well, I wasn't before this morning, but
Sure.
I've heard it mentioned.
I understand that. And you understand there have been allegations of rape made by female prison inmates against biologically male inmates who were transgendered, who have been transferred into female prisons in Washington State and in Illinois. I mean, you wouldn't call concerns like those unsupported hyperbole, would you?
Well, I don't want to comment on the concerns because those issues are ones that are coming before courts and that I might be called to rule upon, so I don't want to characterize the concerns. What I do want to tell you is that when I became a judge, I set aside my role as an advocate and I committed myself to letting the law be my guide, precedent be my guide in case after case. And that is it's what I do now, and it is certainly what I would continue to do if confirmed.
Okay. I see my time's expired. Yeah, I hope you'll take that to heart and take that for what it's worth. There are legitimate concerns. There are legitimate concerns on both sides of this issue, and I think it's important that we not denigrate legitimate desire to protect people, particularly girls and women in the context of restrooms, shelters, prisons, and so forth, from abuse that could occur as a result of opportunistic predators. There are always going to be, when laws and policies are adopted, there are always those who will look for opportunities to exploit them. So I hope you'll realize that there is a legitimate set of concerns on both sides that need to be respected. Thank you.
Thank you, Senator Lee. Before recognizing Senator Cruz, in absence of any of my Democratic colleagues being present at the moment, I did want to ask just one follow-up question to an item that Senator Kennedy raised earlier. Senator Kennedy asked you about the Erie Doctrine, a complicated area of law, understandably, but can you speak generally to the process by which you learn and analyze new areas of the law?
Yes, thank you very much, Senator Padilla. So again, throughout my career as an appellate advocate, there were many times where issues were presented to me in which I had no experience. And same thing happens as a judge, where I sit handling some of cases about some of the most important, most intimate issues in people's lives, and had no experience really in family law before I came to the bench. So my approach in every case is to start by listening to the arguments, reviewing the briefs, reviewing the text of the law, reviewing precedent, looking to any canons of construction, having discussions with colleagues, and really delving into it that way. I enjoy being a judge. I enjoy wrestling with complex issues, and I strive in every case, every time, to get it right. Thank you.
Thank you. Senator Cruz.
Thank you, Mr. Chairman. Judge Thomas, welcome. As I look at your record, it continues a pattern of the Biden administration of nominating individuals to the bench who have long careers as activists. Throughout the course of this hearing, you have explained some of your prior positions as simply representing a client. But when I look at your career, I don't see that. I see that you are passionately committed to a particular vision of the law. It has ranged from filing briefs in litigation in the state of Texas, defending race-based discrimination in university admissions, to most consistently transgender activism, and I would submit extremism. And this hasn't been one client you had in one case. This has rather been a consistent pattern that extended when you were a lawyer for the state of California, that extended when you were a lawyer for the U.S. Department of Justice, that extended when you were a lawyer for the state of New York. In 3 different jurisdictions, you have been involved in litigation on the extremes of transgender issues. And in particular, you've carved out an expertise for yourself using litigation to force institutions to allow biological males to use restroom facilities and locker facilities that are also used by girls, young girls, that are used by women. And this has been a pattern. When you were a lawyer for the state of California, you filed a lawsuit against Crunch Fitness, a gym, for not moving quickly enough to allow a biological male to use the women's locker room. when you were a lawyer for the state of New York, you filed briefs against the state of Texas, against the state of North Carolina, again, advocating for biological males to use girls' and women's restrooms. And you know, the thing I find troubling about these arguments is it seems the women and girls never have any rights. That the girls that would like to shower next to someone who is not a biological male, who would like some privacy, their rights never seem to matter. And your pattern, it's not a single case. It is across 3 jurisdictions over and over again. In the Texas case, the brief you filed said, quote, "There is no data or tangible evidence in support of the claim that allowing people to use bathrooms corresponding with their gender identity will lead to increased violence or crime in restrooms." Do you stand by that statement?
Thank you for the question, Senator Cruz. Again, as an advocate, you advocate for the positions of your client. I haven't been an advocate for 3 years. I've been a judge. And when
3 years is not very long. And my question is simple. Do you stand by that statement?
Senator Cruz, it would not be appropriate or consistent with my ethical duties to my former clients to comment on my personal views about any case that I worked on. What my duty was to advocate zealously for my clients. I have set aside the advocacy role, and I now occupy a judicial role, where what you're
Judge,
guided
your
by.
brief also contended, quote, "In states where anti-discrimination protections are already the law, the predicted safety harm has never materialized." You made a bold, aggressive, factual statement, by the way. In North Carolina, you said safety concerns were, quote, "unfounded." You were an aggressive advocate, an activist advocate. And I believe the statements that you represented to the court, and those are statements that you're making as an officer of the court. I believe they were false, and they are extreme. You testified to this committee that you were not aware of what happened in Loudoun County until this morning. I find that remarkable for someone who has spent years as one of the leading activists for allowing transgender biological men to use girls' restrooms and women's restrooms. In Loudoun County, Scott Smith, who's the parent of a 14-year-old girl, alleged the Loudoun County School Board covered up the sexual assault by a gender-fluid individual against his 9th grade daughter who entered the girls' bathroom in a skirt. And this individual was charged with 2 counts of forcible sodomy, 1 count of anal sodomy, and 1 count of forcible fellatio. The school district covered it up. They released this sexual predator, and the predator committed sexual assault again, twice. Why did you represent to the court that concerns about violent sexual predators committing violent crimes against young girls are unfounded and speculative? Why did you represent that to the court?
Thank you for the question. I advocated on behalf of my clients based upon the data that we had at the time, and I zealously did so in those cases and in every other case that I handled.
Were you right?
Senator Cruz, it would not be appropriate for me to comment on the merits of any personal views regarding litigation that I handled on behalf of my clients.
Well, these little girls who
Senator
were sexually
Cruz,
assaulted
let her respond. Your time
will
is
have
up.
a
Let's
very
let Ms. Thomas
different
respond.
assessment.
Senator Cruz,
These
let
little
Ms.
girls
Thomas
who were
respond.
assaulted. Thank you for your
Time is
views,
up.
but
You're past time. Let's afford Ms. Thomas an opportunity
she
to
is
respond to your question.
perfectly welcome to respond. But as I said, the little girls who were raped in Loudoun County would have a very different assessment of whether this threat and danger is speculative or not, and you're more than welcome to respond.
Thank you. I will just conclude by saying again that I understand the difference between being an advocate and being a judge. I am a judge now, and what I'm guided by is the record before me and the law. And that is what I do now, and it's what I'll continue to do if confirmed.
Thank you, Ms.
Thank you.
Thomas. And for the record, I'd just like to acknowledge that assaults from Loudoun County that our Republican colleagues are pointing to happened earlier this year. And of course, we share sympathies with the victims, but let me note that as a matter of chronology, Judge Thomas worked in the New York Solicitor General's office in the year 2015, 6 years ago. And asking her repeatedly to comment 6 years later as a sitting judge about new facts and matters that continue to come before the courts is unfair. With
Although
no
she was
other
also
members
speaking
present or
predictively
expected-
about what would happen.
With no other members expected for questions, let me thank Judge Thomas for appearing before us today, and congratulations again to you and to your family. Please be mindful that senators may submit written questions following the hearing, and we'd ask that you work diligently to respond to those. And with that, we'll begin to proceed to our second panel. As we do so, let me acknowledge two things. Senator Hickenlooper is now with us in person to make his introduction of Ms. Sweeney. So I invite him to do so now, after which we will briefly recess, subject to the call of the chair, as we continue to set up the second panel. Members who have not voted in Senate chambers, including myself, will go vote and return, and then we will continue with the second panel. Senator Hickenlooper.
Thank you, Mr. Chair, and I apologize for having, we had to be at three places at once. Ranking Member Grassley, I appreciate you all both allowing me to share a few words about Charlotte Sweeney, President Biden's nominee for the U.S. District Court for the District of Colorado. Charlotte Sweeney comes to this committee with 25 years of experience, great legal experience, and great accomplishment. Throughout her career, she has gained extensive experience representing clients both in the private and government sectors of employment law, often specializing in discrimination and cases involving civil rights. Charlotte has dedicated her career to the people of Colorado, fighting for equality and equal justice under the law. Colorado Super Lawyers has repeatedly named her one of the top 50 women attorneys in the state. That's one reason why she has received a rating of well qualified from the American Bar Association. Her nomination is also historic. She would be the first openly LGBT federal judge in Colorado, bringing much needed diversity to the bench. It's also important to note how opposing counsels who have worked with and against Charlotte over the years view her character and credentials. In supporting her nomination, they quote, and I quote, have each found Charlotte to demonstrate the highest qualities of integrity, courtesy, and curiosity, the very cornerstones of the legal profession. I wholeheartedly agree. Charlotte has my full support. We went through many remarkably talented lawyers before settling on pushing her nomination forward. I encourage the committee to support her nomination, and we look forward to the Senate acting swiftly to confirm her. And I thank her again for her public service. Thank you, Mr. Chair and Ranking Member Grassley, and every member of the committee for your consideration of this remarkable and outstanding nominee. And congratulations to Ms. Thomas as well.
Thank you, Senator Hickenlooper. Thank you all again for your patience during this brief recess while we vote, return. In the meantime, we will be setting up for the next round of nominees. Ms. Thomas, thank you again. The Senate Judiciary Committee is back in session. Thank you all again for your patience during our brief recess. We will now hear from our next 5 nominees today. And before asking each of you to make your opening statements, would you please stand to be sworn in? Raise your right hand. Do you affirm that the testimony you are about to give before the committee will be the truth, the whole truth, and nothing but the truth, so help you God? I do. Thank you. Let the record reflect they have all answered in the affirmative, including Ms. Sweeney, who has joined us virtually. We'll now proceed with witness statements in alphabetical order, to be fair. Judge Dimke, you may proceed.
Good afternoon. Thank you to Chairman Durbin, Ranking Member Grassley, this committee, and its staff for holding this hearing today to consider our nominations. Senator Padilla, thank you for chairing the hearing today. I would like to thank the President for the honor of this nomination and my home state senators for the faith and confidence they have placed in me by recommending me for this position, and especially to Senator Murray for her kind remarks this morning. I'd like to introduce my family that's here today. First is my mother, Janice Dimke, joining us from Clarkston, Washington. My father passed away in 2008 from cancer, so he is with us here today in spirit, in my heart, and I have no doubt is thrilled about today's events. I do credit my being here today to the lessons instilled in me by my parents. Having grown up in an agricultural family in Eastern Washington, I learned the value of a strong work ethic and the gift of service at a very young age, and I attribute my having chosen a career path in public service to the guidance given to me by my parents. Representing the remainder of my family, my siblings, and their families is my sister, Monica DeWitt. My husband, Jared Shelby, is here today, who has been my biggest fan and unfailing source of support for the last 9 years. Through my marriage to Jared, I gained an amazing family, which has grown to include my 3 stepchildren, their spouses, significant others, and our 3 grandchildren, Courtney and Lance, Colton and Jessica, Cooper and Bella, and little ones Carter, Ellie, and Xander. My oldest stepson, Colton Shelby, is here as a representative of my family today. Last but not least is Casey Reisman, a very dear friend of mine. We met on our first day of law school at Vanderbilt over 20 years ago. Joining us today, watching by video, are so many friends and family and people who have supported me over the years, including my mentors, Judge Johnson and Judge Tallman, the many court families I've had the privilege of being a part of over the years, colleagues past and present, and most importantly, my incredible chambers team. To them, I say thank you. They made me a better lawyer. They make me a better judge. It is the honor of my career to be here today, and I welcome your questions.
Thank you. Judge Frimpong.
Thank you, Senator. I wish to thank Chairman Durbin and Ranking Member Grassley for holding this hearing, you, Senator Padilla, for chairing this hearing, and all of the senators participating. I am profoundly grateful to President Biden for the honor of this nomination, and to you and Senator Feinstein for your support. I also wish to thank all of my family, friends, and colleagues in both the United States and abroad for their support throughout my career. The judicial officers, staff, and bailiffs of the Los Angeles Superior Court inspire and teach me every day. I am grateful to them all, but I owe a particular debt of gratitude to my judicial assistant of 5 years, Jennifer Medina. It fills me with great pride to introduce my parents to you, Drs. Kweku and Theodora Ewusi-Mensah. As was mentioned, my parents and husband are immigrants from the West African nation of Ghana. My mother often says to me in Fanti, "Koto nwanama," a crab does not give birth to a bird. In keeping with that, it is my hope that every person who enters my courtroom sees some resemblance in me to my parents, their relentless work ethic, insatiable intellectual curiosity, and unshakable moral courage. Also with me today are my husband Yao, who is my best friend, my sister Arama, my father-in-law, Professor Kwame Frimpong, my mother-in-law, Mrs. Agnes Frimpong, my sister-in-law, Nana Frimpong, and my dear friend, Serena Mayeri. Thank you for the opportunity to honor all of them publicly here today. I look forward to answering your questions.
Thank you. Next, we'll hear from Ms. Sweeney.
Thank you. I would like to thank Chair Durbin, Ranking Member Grassley, and all the members of the committee for considering my nomination here today. I would also like to thank Chair Durbin for accommodating me and allowing me to appear remotely. Thank you, Chair Padilla, for chairing this committee today. Thank you also to Senator Bennett and Senator Hickenlooper for the lovely introduction and for forwarding my name to President Biden for consideration. I thank President Biden for this wonderful opportunity and really the highlight of my professional career. I wouldn't be here today, but for the love of my two daughters, Jordan and Addison Sweeney. I am amazed every day that I have been blessed with such two amazing, wonderful young women in my life. I must give thanks to my mother, Greg Ann Sweeney. She has taught me the power and the healing love of family throughout my entire lifetime. I would also like to thank my two sisters, Lynn and Michelle, and my brother, Patrick, and all of their family. We have a giant family watching by video today, and I would like to thank my nieces and nephews, my grandnieces and nephews, aunts and uncles, and all of my family who has gathered here to support me, and thank them for their love today and every other day. We are missing today two very important people in my life. My father, Shepard Sweeney, who passed away years ago. My father gave me the gift of faith and the gift of a very strong work ethic, and I thank him for that. I would also like to honor my grandmother, Nora Gregory Tucker. She gave me the gift of unconditional love and the healing power of love, and for that I will be eternally grateful. I know both of them are looking down with a little sparkle in each of their eyes. I would like to thank my many mentors, colleagues, and good friends, including the travel team, who have been with me on this journey over this last 26 years of my career, and even before that. I would not be here without all of you. I honor and recognize your support and love, and I thank you. With that, Senators, I welcome your questions.
Thank you, Ms. Sweeney. Now let's hear from Judge Thurston.
Thanks to Chairman Durbin and Ranking Member Grassley for holding this hearing today, and to you, Senator Padilla, for chairing this hearing. Thanks also to Senator Feinstein, and again to you, Senator Padilla, for your support. But of course, most of all, I do thank President Biden for the honor of this nomination. With me here today is my husband, Mark Thurston, who's been my best friend for more than 3 decades. Also here is our daughter, Paige, who has taught us everything we need to know about life and laughter and about unconditional love. I am here today to teach her that in this country, she can be anything she wants, and that this country allows her to be the very best version of herself. I also thank my friends, some of whom I've known since kindergarten, who are watching today. I'm very grateful also for the support of my court family, including those who have left our bench. I know that I'm being cheered on by my sisters, Deborah Kutware and Sheremy Daniel, and their husbands, Greg and Dan, and their families. I know I'm also being cheered on by my mother-in-law, Virginia Thurston. I know that my dad, Cliff Calderwood, is bursting with pride, as would have been my mother, Judy, and my father-in-law, Charles Thurston, had they lived to see it. I also want to mention my magistrate judge colleagues in the Eastern District of California and those spread throughout this federal system. I am so proud of this incredible group of federal judges who work so hard every day to bring justice to those appearing before them, often without recognition or thanks, and without whom the federal judicial system would screech to a halt. If I'm appointed to the position of district judge, I assure you that I will work as hard as I have done for the last 12 years on the bench to serve my community and to uphold the rule of law. Thank you very much.
Thank you. And last but not least, Judge Vera.
Thank you, Senator. Good morning. I too want to start by thanking Chairman Durbin and Ranking Member Grassley and all the other senators of this committee for considering my nomination. Special thank you to my two home state senators, Senators Padilla and Feinstein, for the gracious introduction, for your dedication to the people of California, and for supporting my nomination. And of course, thank you to President Biden. It is a deep, deep personal honor and privilege to be here as your nominee. I'd like to introduce, acknowledge, and thank the members of my family who are here with me today, my wife and best friend, Barbara, without whose support and daily encouragement, I would not be able to do this work that I love. She is my inspiration every day. To my mother, Elvira, and my brother, Leandro, who flew out from San Jose and who have not missed an important event in my life in 51 years. I'd also like to thank my two incredible daughters, Limei and Anling. They are both in college and couldn't be here, but I always want them to know that they are the greatest joy in my life. And to my late father, Guillermo, who is with me today in spirit. Y también quisiera mandar un saludo especial a mi familia querida en Buenos Aires. Finally, I'd like to thank and acknowledge my judicial colleagues in the Juvenile Division of the Los Angeles Superior Court, bench officers who work incredibly hard every day serving the children and families of Los Angeles County. And with that, I welcome your questions.
Thank you, Judge Vera. As we begin with questions for each of you, want to observe that actually don't have colleagues from either side of the aisle here at the moment. So I will begin, of course, with questions for about 5 minutes. Upon conclusion of my questions, if there are no other members present, we may be moving to quickly adjourn the hearing thereafter. So if I can have staff on both sides communicate with their senators and encourage them to make their way to this hearing room. Certainly want to afford all of my colleagues an opportunity to ask questions, but we want to be respectful of everybody's time as well. With that, let me begin with Judge Frimpong. Judge, you have now served on the Superior Court bench for 5 years. And in that time, you've heard hundreds of cases ranging from traffic offenses to criminal matters. You've also taken on leadership roles for the court, including serving as assistant supervising judge of the Criminal Division's Infractions and Limited Jurisdictions Courts. By all accounts, and as confirmed by the letters of endorsement submitted to this committee by 12 of your colleagues in support of your nomination, your service on the Superior Court has been exemplary. As a trial court judge, you serve as the court of first impression for litigants and criminal defendants. Some may never have stepped into a courtroom before, and some may be confused by the process and the system. What role can a judge play in helping litigants and defendants navigate and understand a complicated legal system?
Thank you for the question, Senator. I have been fortunate to serve on the Los Angeles Superior Court for the last 5.5 years, and it has been a true honor. What I'm guided by every day in my courtroom are 3 things. First of all, the fact that every person who enters my courtroom is entitled to be treated with dignity and respect. And I think that sets a tone in my courtroom that is important for all the litigants to know that this is a court where their rights and their interests will be respected in accordance with the law and the Constitution. Secondly, because I am in a criminal assignment, liberty and justice are at the forefront of my mind every day, and I want to convey that to all the parties that are before me. And finally, that the role of the courts is limited, and so I take care in every case to ensure that the parties understand that I am doing what I'm doing based upon the law and the law alone.
Okay. Thank you for that answer. I'll also ask a question we can anticipate given the theme of questions you heard earlier today. But we'd love to hear from you. What role should a judge's personal policy preferences play in their evaluation of the merits of a case before you?
They should play no role. I have been an attorney. I'm now a judge. I well understand the difference between the 2 roles. And one of the things that I take extremely seriously is the oath that I took when I became a judge to uphold the Constitution of the state of California, as well as the Constitution of the United States, and to well and truthfully carry out my duties. And my first duty as a judge is to limit myself to the cases before me, set aside any personal views, and decide them only based upon the facts and the law.
Thank you. My next question is for Judge Vera. In your 27 years of legal practice, you've had a diverse and wide-ranging legal career. You've represented corporate clients as a law firm lawyer. You've advocated on behalf of consumers, veterans, and the underserved as a public interest lawyer. And now you adjudicate dependency cases as a judge. You've also managed a large public interest organization, served on advisory commissions, and been an active member of the legal and local community. How will your diverse practice and professional experience contribute to and inform your service as a federal judge?
Thank you very much, Senator Padilla. I think that my diversity of experience gives me different perspectives or angles from which to view the law. I spent about, as you said, about a dozen years working for different litigation firms where I honed my courtroom skills, working on intellectual property, on class actions, on securities, antitrust, and complex torts. And then I spent 13 years at public counsel doing both impact litigation and also the one-on-one representation in community clinics around the county, representing one client at a time in matters relating to housing and education and civil rights and consumer. And I think, and finally, as a judge, being able to put aside that role and put on the robe and view the law from that different role. I think that those three perspectives, as a defense lawyer, as a public interest lawyer, and as a judge, give me that different diversity of experience that I hope will, if confirmed, allow me to hit the ground running. Thank you.
Thank you. And as I proceed to my final question, let this serve as a 2-minute warning once again to my colleagues. Judge Thurston, as the Chief Magistrate Judge for the Eastern District of California, you've already had the opportunity to perform many of the functions of an Article III judge. But the Eastern District of California, as you all know, has an extraordinarily impacted caseload. And your level of work and responsibility will dramatically increase if you are confirmed. Considering your clear insight into the demanding job assignment that you would be taking on in the Eastern District, why do you want to serve there as an Article III judge in this district at this time?
As you pointed out, I've been on the bench there in the Eastern District of California for just about 12 years. And in that time, I have learned all of the difficulties that we face due to the judicial crisis that we're in. I think that's one of the reasons that makes me well qualified for this position, is because I can step in on the first day and start deciding cases. I appreciate the extraordinary burden that will place on me and my family, but I do have this second family, this court family, that I feel I want to step up and help even more than I have already. So it will be my pleasure, if I'm confirmed, to take that role on.
Thank you. Judge Dimke and Ms. Sweeney, question for each of you. I don't have any additional questions for each of you, but I want to thank you for appearing before us. Obviously, you come out well recommended by my colleagues from your respective states, so we do appreciate your time and look forward to supporting each of your nominations in committee and in the full Senate when we get to that step of the process. Short and sweet. Congratulations to each of you once again for your nominations. With no additional senators present or wishing to ask questions, I'll begin to bring this hearing to a close. But before we adjourn today's hearing, I do want to make 2 announcements. Number one, a special thank you to the Judicial Advisory Committee of mine in California that has worked tremendously to not just outreach to potential candidates, but to provide some of the initial vetting and recommending to my office, and obviously names to the White House for consideration. They have produced a tremendously qualified and a tremendously diverse slate that we are considering here today. I also want to make a quick logistical note. Questions for the record will be due to the nominees by 5 p.m. on Wednesday, October 27th. And the record will likewise remain open until that time to submit letters and similar materials. So a big thank you again to all of our nominees, and once again, congratulations to you and your families. And with that, this hearing is adjourned.